5 seconds to go. Start. The learned additional advocate general appearing for the state, on the other hand, has vehemently opposed the present writ application. The learned counsel would submit that the family register is not admissible in evidence and the entries made therein are not decisive to determine the age. It is argued that the writ applicant has not placed on record any document of any educational institution. It is also argued that no ossification test was undertaken or no modern recognized method was adopted for the purpose of determination of age. The learned counsel appearing for the state invited the attention of this court towards the order passed by a coordinate bench of this court in the case of Ashok versus State of Madhya Pradesh, special leave to appeal. The order passed by the coordinate bench referred to above state thus: by a judgment and order, the additional sessions judge, District Bhind, Madhya Pradesh, convicted the petitioner inter alia for offence under section 302 of the Indian Penal Code and sentenced him inter alia to life imprisonment in sessions trial. In the cause title of the said judgment and order, the petitioner has been described as Ashok, son of Balram, age 16 years, 9 months and 19 days, resident of District Bhind. The petitioner filed an appeal being criminal appeal challenging his conviction and sentence. The said criminal appeal has been dismissed by the High Court, which is impugned in the special leave petition filed by the petitioner. The incident which led to the conviction of the petitioner took place on 26th July 1997. The petitioner claims that the petitioner was born on 5th January 1981. The petitioner was therefore approximately 16 years and 7 months old on the date of the incident. In this court, the petitioner has for the first time contended that he was a juvenile on the date of the incident. His conviction and sentence are therefore liable to be set aside. The claim of juvenility was not raised in the High Court. The learned additional advocate general appearing on behalf of the state argued that the claim of juvenility has been raised for the first time in this special leave petition. The Juvenile Justice Act 1986, which was in force on the date of commission of the offence, as also the date of the judgment and order of conviction and sentence. Under the 1986 Act, the age of juvenility was up to the 16th year. Section 7A of the 2000 Act, as inserted by Act 33 of 2006, with effect from 22nd August 2006, provided as procedure to be followed when claim of juvenility is raised before any court. 1. Whenever a claim of juvenility is raised before any court, this court is of the opinion that an accused person was a juvenile on the date of commission of the offence, the court shall make an inquiry, take such evidence as may be necessary so as to determine the age of such person, and shall record a finding whether the person is a juvenile or a child or not, stating his age as nearly as may be, provided that a claim of juvenility may be raised before any court, and it shall be recognized at any stage, even after final disposal of the case, and such claim shall be determined in terms of the provisions contained in this Act and the rules made thereunder, even if the juvenile has ceased to be so on or before the date of commencement of this Act. 2. If the court finds a person to be a juvenile on the date of commission of the offence under subsection 1, it shall forward the juvenile to the board for passing appropriate orders, and the sentence, if any, passed by a court shall be deemed to have no effect. The claim of juvenility can thus be raised before any court at any stage, even after final disposal of the case, and if the court finds a person to be a juvenile on the date of commission of the offence, it is to forward the juvenile to the board for passing appropriate orders, and the sentence, if any, passed by a court shall be deemed to have no effect, even though the offence in this case may have been committed before the enactment of the Act of 2000. The petitioner is entitled to the benefit of juvenility under section 7A of the Act of 2000 if on inquiry it is found that he was less than 18 years of age on the date of the alleged offence. It is true, as pointed out by the learned additional Advocate General appearing on behalf of the state that the certificate of high school district Bhind, Madhya Pradesh relied upon by the petitioner is stated to have been issued on 17th July 2021. The said certificate does not mention the date of birth as stated in the certificate. Stop.